You're listening to the Quint's podcast.
Despite mounting criticism, Yogi Adityanath's government in Uttar Pradesh approved a very controversial ordinance on 24th November, which is seemingly against unlawful religious conversions but has been repackaged as a way to combat Love Jihad. This law declares marriages after a conversion without permission to be null and void. As much as Love Jihad continues to be an unproven conspiracy not just in UP but in India generally, this law provides for up to 5 years of rigorous imprisonment and Rs 15,000 as penalty, but the punishment is stricter for conversions of minors and women of the SC/ST communities. It comes with 10 years of imprisonment and Rs 25,000 as penalty. But this move also shockingly comes around the same time when the Allahabad High Court struck down 2 previous orders by single judges of the same court that Chief Minister Yogi Adityanath had previously quoted as a basis for the anti-Love Jihad laws. Those verdicts had held that religious conversion purely for the sake of marriage was illegal. But on 11th November, a division bench of Justices Vivek Agarwal and Pankaj Naqvi held that neither of the 2 rulings were quote-unquote good law, as they don't consider, quote, the liberty of 2 mature individuals in choosing a partner or their right to freedom of choice as to who they want to live their lives with, end quote. So what kind of a precedent is the Yogi government setting with this law that even in the court's view goes against the fundamental rights of citizens, that too without enough evidence to support the government's claims on Love Jihad? In this podcast, you'll hear from Mihir Asood, a Supreme Court lawyer who's currently researching the Indian women's movement and its use of criminal law, and the Quint's legal editor, Vakasha Sachdev. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shorbury. Uttar Pradesh is one of the 5 BJP-ruled states that propose to pass laws to combat the supposed menace of quote-unquote Love Jihad. The other states are Madhya Pradesh, Haryana, Karnataka and Assam. And this despite the fact that Love Jihad is not recognized by the Indian law or for that matter even the BJP-led central government. In a previous episode of The Big Story, we deep dive into how there's not much of a legal basis for Love Jihad laws, how it can affect interfaith couples who often choose the option of religious conversion, since the Special Marriage Act is an especially cumbersome process, how this whole law undermines and infantilizes adult women and their choices. And we also talked about how despite BJP leaders themselves promoting the conspiracy of an alleged scheming by Muslim men to convert Hindu girls through marriages, there's been no proof of it so far. In case you missed that episode, you can find the link to it on the show notes. But announcing the approval of the ordinance, Cabinet Minister Siddharth Nath Singh said, and I'm quoting his statement, "The way in which religious conversions are done using deceit, lies, force and dishonesty is heart-wrenching, and it was necessary to have a law in this regard," end quote. He also added that if a person wants to perform marriage after converting into any other religion, they will need to take permission from the relevant district magistrate 2 months prior to the marriage. But the one important thing that the UP government seemed to have overlooked is the lack of evidence of Love Jihad cases in the state. In August 2020, the Yogi government had directed senior officials of the State Home Department to prepare a plan to stop incidents of Love Jihad, as apparently there were quote-unquote increasing cases of Love Jihad being reported from different parts of the state. And a report from 29th August on the Indian Express reads, and I'm quoting a few lines from the report, quote, "Following several cases of interreligious marriages in Kanpur's Juhi colony, the police had formed a special investigating team to probe allegations of conversion either by force or by quote-unquote brainwashing the women before marriage. The SIT was formed after families of 5 women from Juhi colony met senior police officials and sought help, alleging that the women were allegedly brainwashed into converting before marrying," end quote. But even as the government passed the ordinance, the special investigating team that had set to probe the Love Jihad cases in concern shattered the claim of quote-unquote rising Love Jihad cases in UP. The SIT submitted its report on 23rd November, ruling out any conspiracy angle in 14 of such cases that it investigated. They also found no evidence of external funding from abroad towards the Muslim youths involved in these cases. And this is not just the case from UP alone, but different probes in different states like the CID probe in Karnataka in 2009, for instance, Or in the case of Hadia, the NIA probe into Love Jihad also failed to prove any conspiracy angle. So then, what kind of a precedent is the Yogi government setting with this ordinance? Mihira Sood, a Supreme Court lawyer, says that there's no legal basis for this law. In fact, it violates the constitution and targets specific genders and religions.
There is no rational legal argument on the basis of which these laws can be upheld in a constitutional court, in my opinion. They are vague, they are prone to abuse, they discriminate on the basis of gender and religion, and they violate the constitutional guarantees of freedom of religion and personal liberty, including the right to marry a person of one's choosing. These laws also reek of infantilization, denying grown adults the freedom to choose their own faith or their own life partner. And let's also be clear that they are not religion or gender neutral. It is evident from the language and rhetoric surrounding these laws that the target is conversions to Islam alone, and specifically conversions by Hindu women. As usual, it is women who are treated as nothing more than vessels for community honor here, who need to be policed and controlled, and it is their conversions that is a cause of concern for the right wing. As with many other laws, these too claim to protect and empower women while doing the exact opposite.
But it's not just the blatant and visible contradiction between facts and claims made by the UP government that is concerning, but also a disregard for the judiciary. Yogi Adityanath had quoted a rather contentious Allahabad High Court observation from earlier in October this year, which in turn referred to an older but similar observation on religious conversion made by the same court in 2014. And as we've already said, the judges had observed that religious conversion just for the purpose of marriage was unacceptable. Even though the state's chief minister had openly cited those rulings as a justification for the necessity of Love Jihad laws, recently, as we said on November 11th, the same court denounced those judgments as they were not quote-unquote laying good law. In a stark contrast to the provisions of the proposed Love Jihad laws, the High Court asserted that the matter of a religious conversion is irrelevant if both the parties are adults and in a consenting relationship. The right of two adults to stay together cannot be encroached upon by the state, and Vakasha talks a little more about this recent judgment.
So, first off, the Allahabad High Court judgment. Now, this was actually something which slipped under the radar quite a bit because the order was actually passed in on 11th November, and we all sort of almost seemed to miss it. I think, in fact, Laila found out about it. But it's a remarkable order when you actually look at it, and it very cleanly hits a lot of the things which were being done. The sort of propaganda around Love Jihad and the way it was being promoted by the BJP in recent months. Now, if we look at that the sort of two Allahabad High Court orders, which were a major problem here. Now, in those two orders, the High Court was being approached by interfaith couples asking for protection, from from the police harassment or from other thugs or from anyone else, so they were trying to get a court order to do that, which is something which the court should have done the moment they were satisfied that there was a risk to these of any harassment to the couples. Instead, the judges go into some this convoluted. In fact, it was single judges in both of those, which was why it was struck down actually, where it was easy to strike it down actually. And those single judges went into their own patriarchal notions of, oh well, if the marriage isn't legal, then we shouldn't really get involved, and why are people converting only for the sake of marriage, and we don't think this is right. And then to try and justify that, they were they were citing the 2006 Supreme Court Lily Thomas decision. Now, the thing is, that was a complete misreading of Lily Thomas, because Lily Thomas, the 2006 Supreme Court decision there, was about a case where you had a Hindu man who was already married to a Hindu woman, wanted to marry a second Hindu woman, and so to try and avoid having to, deal with the divorce issues and deal with any other obligations he had towards his first wife, he was like, oh, you know what, if I just convert to Islam, then I can, have my second marriage. And that's what it was about, and that's why the court said that the marriage there was a sham. So the conversion there was a sham and was therefore illegal, and therefore, even the marriage was not valid. Now, that's a very different set of circumstances than where you've got two people who have no pre-existing obligations to anyone else. They're both adults. One of them says, you know what, I'm going to convert to your religion, and then let's get married, which there are many good reasons to do so. I mean, the Special Marriage Act is supposed to be the great savior for interfaith marriages. But actually, it's a complete nightmare because it has a 30-day notice period. Some states require people to put ads in the newspaper, put a notice at like the DM's office, at the courts, at all these kind of crazy things, which actually then makes them targets for harassment by right-wing goons, by the families, so even when they're running away from the families who are trying to oppose them, and of course even the police at times. Now, the whole idea behind having the Special Marriage Act is to prevent that, but actually it's becoming a facilitator of abuse, which is why many couples say, let's just make sure we both have the same religion, and then we can get married with all the formalities completed easily. So there is a lot of basic reasons why someone might want to do this. In the Allahabad High Court, those previous orders were extremely regressive because they were ignoring all of this context. And that's why it is great to see the division bench of the High Court, which is two judges, so which is why they can overrule what had been done earlier. They looked at it and said that those orders were not good law. And there's some very, very important things which they said there. Right to live with a person of his or her choice, irrespective of religion professed by them, is intrinsic to the right to life and personal liberty. Interference in a personal relationship would constitute a serious encroachment into the right to freedom of choice of the two individuals. So that's one line. Another great line there is, that they said they don't look at the couple in this case as Hindu-Muslim. They say we are just looking at them as a couple who are living together. We fail to understand that if the law permits two persons, even of the same sex, to live together peacefully, then neither any individual, nor a family, nor even state can have objection to relationship of two major individuals who out of their own free will are living together. Now that pretty much sums up exactly why these love jihad laws and why the UP ordinance are a complete joke, because they are saying that if you have a conversion for the sake of marriage, automatically the marriage is going to become void. They're just disregarding the decision of someone who is an adult, who's not even been coerced into doing something, to say that this would not be acceptable. And that's where they all are likely to fall flat when it comes to any challenge in the court. Now, there are separate issues about whether or not this challenge will be heard on time, how efficacious the court will be in hearing it. But if we look purely in terms of the law, the grounds which were used by the Allahabad High Court in this order are what would be used to strike down these provisions.
But considering that there's not just one ruling that nullifies the whole rhetoric of love jihad, but also significant rulings from the Supreme Court in the Hadia case, in the Shakti Vahani case on honor killings, and of course the landmark right to privacy judgment, can these judgments form the basis of revoking this contentious law? Back to Vakasha here.
So let's recap again. What are the provisions we're looking at? We're looking at things saying that any conversion for the sake of marriage is illegal, or presuming that a marriage like this, where there has been a conversion, will be presumed to be void, or can be invalidated by a third party, not even by the couple, by saying that the district magistrate has to give permission 2 months in advance of this kind of for a marriage where one party is converted. These things all interfere with the person's personal autonomy, with their personal choice. And there's a whole line of Supreme Court judgments which deal with this now and really sort of clarify the position. All of these were referred to by the Allahabad High Court in their order. So yet again, another reason why it's so good. The three main cases to look at here are the right to privacy case, which the Puttaswamy judgment from 2017, the first one there, which was that, if you remember, the whole fanfare over a 9-judge bench affirming the right to privacy. Now there the court had said that personal choices about your life, whether it's your a personal intimacy, marriage, where you stay, who you stay with, your sexual orientation, all of this is under it, is fully within the scope of personal autonomy and within your right to privacy. And the judges expressly said there, and I'm going to read out here the line again, the constitutional right to the freedom of religion under Article 25 has implicit within it the ability to choose a faith and the freedom to express or not express those choices to the world. So, even if you're just choosing a faith for convenience, that's your business, and it's nobody else's business to get into the picture unless and until there's clear proof that you've been forced or that you're not a major, that you've not attained 18 years of age. Then there's the Shakti Vahini case, which was the one about honor killing, where this, of course, referred to the Supreme Court's decision in the Hadia case, where, if you remember, a Hindu girl had converted to Islam, married a Muslim man. Her father had lost his lost his marbles over it and was running around filing habeas corpus petitions. So in the Hadia case itself, the court had clearly said that the court or the relatives of the petitioner cannot substitute their opinion or preference for that of the petitioner in such a matter. And so who you live with, which faith you follow, where you reside, that's up to you once you've turned 18, The same thing was buttressed again in the honor killing case, where they were trying to talk about how, society and all should have no role to play here. The judges said there, when two adults marry out of their volition, they choose their path, they consummate their relationship, they feel that it is their goal and they have the right to do so. And it can unequivocally be stated that they have the right, and any infringement of the said right is a constitutional violation. So basically, very clearly, these provisions of these love jihad laws, which are being pretended to be called sort of religious conversion laws, would fall foul of this because they're affecting your decisional autonomy under the right to privacy, they're affecting your right to practice of faith under Article 25, and therefore would be blatantly unconstitutional. And as we've already pointed out elsewhere, this is there's actually no legislative need, because any actual case of forceful conversion or kidnapping or taking someone away for marriage, all of these, there are existing IPC provisions for all of it. So, there's no need, and this stuff is unconstitutional. So that's where we're at with the law.
If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.